Hi, everyone. Welcome to our CLE. We're going to be learning about representing a low-income tenant in municipal court. Glad you're all here today in person and virtually. So my name is Kate Petrogallo. I'm a staff attorney at Philadelphia VIP. So I want to start. First, I want to read the CLE QR code announcement, and we'll have it right here for you all. So for those requesting CLE credit, this QR code will be displayed at the beginning of the program, which you can scan with your smartphone or your tablet's camera, which will link to the CLE web form. Select the sign-in option at the beginning of the program and submit your sign-in time. At the end of the program, the QR code will be displayed again, and you will select the sign-out option and complete the required fields, including selecting the sessions you attended and providing the CLE codes announced during the session. The web form is also available.
Can I interrupt? Has anybody had trouble getting in? They weren't taking my credentials.
Is anyone having any luck?
I just scanned it and it let me, but I'm also on like a Dechert device. So,
sent to everyone in their email before the training.
I was able to do so, and I am not on a Dechert device.
Yeah, I clicked the link that you sent me in the email and signed in via that link.
and would it be possible we could just put the sign-in link in the Zoom chat? Perfect. So if you're having trouble with the QR code, we'll have it in the Zoom chat momentarily.
Okay. Let us know in the chat if you're having any other issues with it. So like we said, we're going to put the link in the chat. Make sure you sign in and out of the program. And then there will be 2 codes throughout the presentation that I will give out so that everyone can submit the codes. Let us know, like I said, in the chat if there's any issues. Okay. So we're going to start out with some introductions, and then I will go into a little bit about Philadelphia VIP, and then I will pass it off to our presenters, and they will get into the nuts and bolts of representing a tenant. So like I said, my name is Kate Petrogallo. I'm a staff attorney here. So most of my work is working up these landlord-tenant cases, placing them with a volunteer, and then supporting the volunteer throughout that process if they have questions about maybe opposing counsel, the processes of municipal court, or the actual defenses that their client might have. I also take a small number of direct representation cases myself, so I am in municipal court and can have that knowledge of what's actually going on in municipal court. All right, Tom and John, you guys want to introduce yourselves?
Sure. Good morning, everyone. I'm Tom Siller. I'm a supervising attorney from Community Legal Services. I am in landlord-tenant court twice a week. That's probably 70%, closer to 80% of my work representing tenants facing eviction. In addition to that, I handle some cases in the Court of Common Pleas. Those are more affirmative cases that we file against landlords or property management companies for a variety of reasons. I've been at CLS now for about 18, 19 months, and I'm happy to be here.
Hey, I'm John Gaynor. I am a counsel. I'm based in Dechert's Philadelphia office here. I am a frequent volunteer for landlord-tenant representations. I have been working with tenants in Philadelphia in eviction defense for about 12 years now. And I really love getting to help real Philadelphians deal with and kind of manage their way through housing insecurity. And I think it's a really rewarding and uplifting kind of experience where you get to help a person feel heard, address their issues, and give them a little bit of peace of mind. And I really hope that all of you are able to enjoy this program today and use it as an opportunity to take more of these representations because they're truly special.
Thank you both. All right, so I want to just get into a little bit about Philadelphia VIP. Like John said, hopefully after today's training, everyone might want to take a case. We do have, there's an extreme need of landlord-tenant defense in Philadelphia. So hopefully you all feel empowered to take on those cases yourself. All right. So Philadelphia VIP, we have our mission here. We were founded in 1981 as a collaboration between the legal services sector in Philadelphia and the private bar to deliver legal services by using volunteer attorneys from law firms and corporations, retired attorneys. So this is how attorneys can get involved in delivering legal services if they're not working at these organizations like CLS, PLA. And you can really help Philadelphians who cannot afford to get an attorney. So we have a leveraging model. So we do have attorneys on our staff, but our main job is to recruit volunteers, train the volunteers, and then we can provide mentors for new volunteers. We also vet cases for volunteers so that we make sure that they have a good experience, as good of an experience as possible with their case. So just to get into more of why we need legal volunteers. So Philadelphia is one of the poorest large cities in the United States. About a quarter of Philadelphians live in poverty, and the demand for affordable or free legal services far exceeds the supply. Legal aid organizations, they can't, handle every single one of these cases, and that's where volunteers can step in and try and close that gap. We often say that we are the agency of last resort. A lot of our clients are coming to us because for whatever reason, they couldn't receive help from one of the legal services organization. Maybe it's because of capacity or the details of their legal problem. So oftentimes when they come to us, we're their last shot, and in turn, a volunteer is their last shot at getting an attorney. So a little bit about the clients that we serve. We serve both individuals and families in Philadelphia. The average income of a client that we have who's, it's just them and their household is about $15,000 a year. We do help with other, types of cases other than landlord-tenant. So if you are interested in taking a case, we can, help you with whatever you're interested in and find a case for you. I already introduced myself as a staff attorney. We also have pro bono case managers who work up these cases and could also be your contact person on a case. We have volunteer mentors, and we have a ton of resources and guides on our website. And there's a specific landlord-tenant training manual that was sent out in the materials. This is just an example of a case summary that we would have on our website, and we would also send to a volunteer attorney if we're trying to see if they're interested in a case. So it just gives you, all the details about the case coming up, gives possible defenses. Those are what's highlighted in yellow there, and kind of just gives the volunteer attorney an idea of what they might be getting themselves into if they take a landlord-tenant case.
I want to jump in. Big practice tip for anybody who's doing this: read these summaries and the notes that VIP prepares, because they're very good and they really do give you an excellent lay of the land in terms of the defenses that are evident, like from the conversation with the client, the tenant, and give you an opportunity to really think about how you're going to approach this stuff. So a young attorneys, particularly, maybe you're not used to relying on the resources, but the staff at Philly VIP really does an excellent job preparing these and really pay a lot of attention to what they flag. If it's not in your list, it absolutely should be. Sorry.
Thank you. No, I appreciate that. All right, so I'm going to pass it off to Tom and just get into the background of eviction in Philadelphia.
All right. So people don't end up in landlord-tenant court overnight. There are a few things that have to happen before a landlord can take a tenant there. Number one, there has to be a landlord-tenant relationship. If there's no lease, whether oral or written, you don't have standing to file in landlord-tenant court. And then there also has to be an alleged breach of the lease. The most common is obviously non-payment of rent. Sometimes it could be some other violation like subletting the property, having unauthorized occupants stay there for more than 2 or 3 nights, which is sometimes spelled out by the lease, things like that. So it's always important, as John just alluded to check the contents of the complaint that the landlord files, because what are they actually filing for? Are they filing for non-payment of rent, or are they filing for some other reason? And before I get into this, the first thing I'll say is that in best case scenario, you avoid going to landlord tenant court altogether. If you're a tenant, a landlord theoretically can file in landlord tenant court after just 1 month of missed rent. So in an ideal world, it's always best to have a person-to-person conversation. The amount of cases that can be avoided just when 2 people sit down in good faith and talk is astounding. That being said, I think some of the issues in Philadelphia are really, in terms of what the tenants face, can be pretty dreary. We're pretty high amongst large cities in eviction rates. Many of the tenants are unrepresented in court. That's gotten a little bit better. But as you'll see here from this statistic, landlords are represented 87% of the times and tenants are represented 16% of the time. Some of the outcomes you'll see for defendants, a default judgment, 36%. That's where a tenant does not show up to court and the landlord just gets a judgment in their favor automatically. This one's very important because sometimes you'll see 2 people on a lease, maybe 2 friends or siblings or 2 cousins. Only one person shows up because maybe the other person moved out and told the landlord, hey, I'm not living there anymore. But if the landlord doesn't take you off the lease, you still have to show up to court and answer for that. If you don't, that's a default judgment against you. These are just some things that I think if you're unrepresented, you're less likely to catch. Now, right to counsel and the eviction diversion program. Right to counsel was passed a few years ago, right before COVID. It was designed to target people in low income areas. I think there are 5 zip codes right now currently that are covered by right to counsel. Basically, these are areas that are deemed low income, and people who are from those zip codes are automatically entitled to an attorney in landlord tenant court, whether it's from Community Legal Services or one of our kind of partner organizations. The eviction diversion program was launched in COVID. The whole point of this is to settle things prior to going to landlord tenant court. So before you can even take a tenant to landlord tenant court, you have to file a notice to vacate, which is telling the tenant, hey, I'm asking that you move out of the property within 30 days. You owe this amount of money. If you fail to do so, I will be taking you to court. A lot of times tenants see this and they get really alarmed because it says, notice to vacate, you must leave the property immediately. That is not an eviction. The only person that can order a tenant evicted is a judge. A landlord does not have the authority to do so. After the landlord does that, after that notice to vacate period ends, they have to participate in the eviction diversion program. From the day that they file in the eviction diversion program, and that's something that a landlord fills out online. It's a very easy process. There will be a case manager involved to try and get the 2 parties to see if they can work something out. What working something out would look like is some type of repayment agreement. Maybe, okay, you fell behind 2 months rent. So, you lost your job. If you're going back to work, you'll start paying rent in the beginning of October. And then in the middle of October, you'll pay us an extra $300 and we'll let you stay. Beautiful. Everyone signs off on that. And then there's no need to go to court. This is nice because it eases the burden on the court system from hearing a lot of cases, which the court system does have a lot of cases. But it also ensures that the landlord still gets paid and the tenant has a roof over their head. So everyone kind of wins. It's also nice for the tenant because anytime you get taken to landlord tenant court, that court filing will always show up on your name if someone runs like a background credit check or a tenant history check. Even if you end up winning the case, the landlord withdraws it, or you end up paying a judgment and then getting it satisfied or vacated, it will always show up. So it's always kind of nice and there are ways that you can challenge things with credit bureaus, but it's kind of nice to not even have to do that. So the eviction diversion program, if it's properly used, is a beautiful thing. Another really nice component of the eviction diversion program is TFA, Targeted Financial Assistance. Targeted Financial Assistance is it's pretty, they do a pretty good job. They will pay up to, I believe it's 3,200 right now in arrears, so back owed rent. And then in addition to that, up to 2 months moving forward. So this is really great because let's say if the landlord files or wants to file for non-payment of rent for, 3 missed months, and the tenant, the rent is $1,000, let's say, which is not uncommon for someone in a right to counsel zip code. Targeted financial assistance would pay off all of those arrears and then give the tenant 2 more months of rent. Now, the nice thing about this is that earlier I said that once a landlord files and fills out the eviction diversion program, they have to wait 30 days before actually taking the person to landlord tenant court. If the landlord gets paid out by targeted financial assistance, they have to wait 60 days past the point of when the rent was made current, which is nice because it gives the tenant a chance to catch their breath. It also makes sure the landlord gets paid, and then it again eases the burden on the court system. Typically, my organization, Community Legal Services, we don't normally represent tenants in the eviction diversion program. Number one is just because of staffing. We have a very high volume of cases in landlord tenant court. But number two, it's kind of an informal, just the informal nature of the program. There normally is a mediator involved, and it's also at that stage things are a little less contentious. So it's almost kind of nice if the two parties can just sit down and have more of a human to human conversation. Things escalate a lot, or things can escalate much quicker once lawyers get involved.
Preview, eviction compliance with the eviction diversion program is. Sorry, I was muted. Compliance with the program is mandatory for landlords. They have to do good faith, reasonable good faith compliance as defined by the city, not the landlord. And it can be a defense that you can use. We'll get into more of that when we get into defenses. Okay, am I up? All right, cool. So I am not a litigator. I am a transactional lawyer, but I like doing these cases. And what is the center of these cases is a contract. So I'm very comfortable when I take up a case, and the very first thing that I do after I read the summaries, and so I think when the second part of this, we'll talk about some of the logistics of starting a matter and responding to VIPs, requests, running conflicts, that sort of thing. So we're now at the premise where we've started the matter. We have engaged the client. Before I even talk to the client, though, I will get the materials and I will read the lease, because the lease centers on a lot of the requirements and gives you a good sense of what is going on. And so if we can go up one. So, when you're going through and looking at the lease, it is generally a requirement that if it's a written lease, it is an exhibit to the filing. So you will have access to the lease in the court's records. I can say in the time that I've done this, I've never seen an oral lease come up. I've seen only written leases. So, in the case that you do somehow have an oral lease, you got statute of frauds issues, you got all sorts of things there. So let's hold that aside, because I think that's like the vast minority of cases. Normally you've got a written lease, so you should read the dang thing. They're usually not long. They're usually written for anybody to understand. And you're really looking through the lease to understand what's the kind of background of the situation. You should look at the term. Are we past the term? Were there renewals? Are there renewals that that aren't documented in any way but happened kind of automatically or not? Like, has the lease converted from a lease with a term to a month-to-month lease? All of these things matter, and they really help you kind of figure out, the situation on the ground. You also want to look at the requirements in the lease, like if the landlord is alleging, failure to allow the buyer of a house to inspect the property, like did the landlord comply with notice requirements under the lease? does the lease cover attorney's fees? Many leases don't specifically say that the tenant is responsible for paying the landlord's attorney's fees in the event of some sort of conflict between them. And you want to understand whether or not the tenant agreed to that in the lease. You want to know who's responsible for which utilities. You want to know what kind of breaches are in the lease. Are there breaches because of pets? Are there breaches because of having guests over a period of time? Those are the sorts of things that like you're looking for in the lease, because you really want to understand what's allowed and what isn't. Very often looking at the lease, you also kind of start to then make sense of the amounts that are being claimed in the landlord tenant complaint. And so I have very often seen landlords, get the number they're asking for in the judgment on the complaint wrong. And so knowing how the lease works out and knowing what's actually contractually required to be paid, when late fees are required and when they're not, when there's like extra charges, like very often, they can get it by the court and get it filed successfully, but it's not in accordance with the terms of the lease. And so even without any real risk, you can, find ways to knock off how much your client might actually owe when you're finally getting that down to like a number. So long story short, read the lease carefully because it gives you a lot of ground to understand what's going on. So we're going to talk a little bit about some of the common defenses that you'll see. And, thank you. I didn't see it. And so three of the more important ones that a lot of us have had success in terms of using as defenses to protect tenants and really, assert their rights well are the ones on the screen right now. Failure to have a rental license or to have a rental license for the entire term, the certificate of rental suitability requirement, and the lead paint ordinance. And so just kind of breaking this down step by step, under the Philadelphia Municipal Code, a landlord is required to be licensed for the entire period for which they are seeking rent from the court. And for any period where they are not licensed, they are not entitled to rent. So the court has been doing a better job of this lately, and many landlords' attorneys have been forced to adjust the amount they're asking for based on non-compliance with the licensing requirement for a period of time. But you should have in your own mind what period was the landlord licensed? Were they licensed for the entire time? Was there a gap? And you'll be able to find this stuff. You'll be able to find the rental license by searching, is it like lni.phila.gov? You'll be able to find out the licensing compliance and if there's a gap on that website. And so you should always check this yourself and make sure, because, while the court is doing their best, they may, you may notice something that they didn't, and it's an opportunity for you to kind of add some value and protect the client. But this is a full defense against eviction and payment of rent if they're not actually licensed. Again, the courts are doing a better job on this anymore. And if there is non-licensed, very often it doesn't get to landlord tenant court. And if a landlord is represented, they're very likely to be in compliance with the licensing, but they may have gaps. And again, part of building out the case and building out an effective defense for your tenant is figuring out, even if I fail on every other argument I might make, what are they contractually required to pay, and what's the most that they're allowed to claim in court? And the licensing requirement is kind of key to helping you understand that. So another requirement is this certificate of rental suitability. So basically, you get the certificate of rental suitability by going on to, if you're a landlord, going on to the LNI website. And then if you don't have outstanding violations, you can kind of print it out. It's like really easy to get the certificate, but a lot of folks don't end up complying with this requirement. And the Philadelphia Municipal Code specifically says that a failure to deliver this certificate of rental suitability dated no later than or no earlier than 60 days prior to the start of the tenancy is a complete defense against payment of rent. What you'll very often see, so it used to be landlords, in the early days, landlords just would ignore this requirement, and it was pretty lovely because you could win like full out the case by them failing to comply. The courts have lately been enforcing delivering this certificate as part of the complaint. So at the very least, you've got a certificate dated as of the date that the complaint was filed or delivered to the tenant. And so they at least can start claiming rent from that point on if they failed to comply beforehand. This is an important defense too, if they can't prove that they delivered this at the inception of the tenancy, or if they delivered it in a way that was ineffective. So for example, it's dated 61 or more days prior to the start of the tenancy, you've got a defense. And it might also work in the same way that licensing does, where if there's a gap, they're not entitled under law to claim the amounts. This one's a little dicier. It can be murky. It can be a he said, she said, and like getting back into if you ever get in front of the judge, they may not credit you in the argument that that the certificate wasn't delivered at the inception. If the landlord is there and is saying that they did, and the tenant is saying they didn't, even though the burden of proving that is actually on the landlord in court, judges very often, as the finder of fact, are, not going to believe us or take our side. And that's just like a fundamental reality in representing disadvantaged clients in landlord-tenant court. The other element of this is the requirement of delivery of the City of Philadelphia Partners for Good Housing Handbook. The handbook is interesting. It sets out kind of the rights that a tenant has. It explains to them, like, what they're entitled to under law. It gives them resources and phone numbers and things. It's a pretty helpful resource for people to have. It's some landlords attach the Partners for Good Housing Handbook to the lease and have it signed as like a delivered thing. Same thing with the certificate of rental suitability. But proving that they delivered it or not can be hard, and the delivery or not is not always included in the material. So it's always kind of a question. This is not one I would hang my hat on if they otherwise complied with the certificate of rental suitability requirement. But it is something to keep in mind because compliance requires both delivery of the certificate and the handbook. If you fail to do both, you haven't complied with the requirements under law. So, not as powerful as a rental license or the failure to comply with the certificate of rental suitability, but worth keeping in mind. The other thing I'll note is if there are some very serious L&I violations, effectively void the certificate of rental suitability. And, it's always important to understand, the client's background and whether they've reported things to L&I, whether L&I is inspected, and you can check for any given rental property whether or not there are outstanding L&I issues. And the rule of thumb is if the issues are severe enough where a landlord couldn't get a certificate of rental suitability printed at that time, then they're severe enough that you can assert it as a defense against whether there's a valid certificate of rental suitability at the time. All right. Last of the kind of big three that are kind of like knockdown, drag out are compliance with the lead ordinances. So Philadelphia recently changed over to a new regime. It used to be back in the day that you really only needed lead disclosure if a property was built before 1978 or if a child, and you needed a lead safe certification if a child under 6 lived in the property. But now it's every zip code in Philadelphia and it's all the time. So for any tenancy, a landlord is required to deliver a lead safe or lead free certification. I want to pause on this because this is an important distinction. I made this mistake once in a representation, so I'm giving you guys kind of the benefit. Lead free certifications are different than lead safe certifications. Lead free certifications are permanent. If a landlord gets a lead free certification, it doesn't need to be renewed. There doesn't need to be a new inspection. And so if they get that inspection one time, they can then reuse that certification for future tenancies. For newer built stuff, you're going to see this come up more, that they'll just get lead free. Checking to see whether or not the lead safe has been complied with. You can find out when the property was built based on the records on L&I. I think it's there. And then you should have evidence. They're also required to certify to it in the complaint. But you can find out when the property was built, and you can see, usually they attach the lead certificate to the complaint itself or part of the lease. If you don't find a lead certificate, you need to inquire about that, because the lead disclosure and the lead requirements are actually like very substantial. It is not just a defense against payment of rent. You can go back and claim, make a counterclaim for rent paid. And so it can be really powerful. It can be very frightening to landlords. They generally do a good job of complying with this, but now and again, you'll see it. And so when you identify any of these lead issues, really pursue it, because it can be powerful leverage in securing a good result for the client. And so, the defense is, the one thing I'll note about the damages and the refund is that these can be kind of significant amounts. And if you want to make anything more than an oral counterclaim, you will need to file the counterclaim for the violation of the lead ordinance. Now, given timing, that can be tough, because a lot of the times, the need is so great for volunteers in these cases that you may only have 2 weeks before your case starts, or even less. And I think it's 10 days to file a counterclaim. So, if you spot a significant lead issue, if there hasn't already been a tenant side continuance, you might consider advocating or talking to your client about asking for a continuance to give you time to prep the issue. My view on this stuff is that, like, we're defending clients. We're not necessarily trying to like help anybody achieve windfalls, but if there's been danger, if it's like the best for the client's case to assert this right and really push for the leverage, you really ought to make sure you take the time to do it, because it's a very substantial and powerful defense.
And I'll just
Yeah, of course.
hop in briefly. I think I agree with everything John was just saying. I think one of the big things in pursuing a lead claim against the landlord is using it, like John just alluded to negotiate a more favorable settlement. Out of the three certificates that he just covered, the lead safe certificate is actually the only one that you can sue the landlord for periods of non-compliance where you were paying rent. So, like, in other words, if a landlord didn't have a rental license for a year and the tenant was paying rent for that year, the tenant is not entitled to sue the landlord and recoup that rent. Same with the certificate of rental suitability, but for the lead safety certificate, they are. I think this has only happened to me once, but in one instance, I had a case where the landlord did not have the lead safe certificate, and my tenant, my client, had a small child who was developing some sort of like cough and pretty serious medical issues. Long story short, she was very thorough. She could have been her own lawyer, quite frankly, but she had a doctor write an evaluation saying that, like, some of the illness that the child was displaying was from possible exposure to lead, which was really powerful and like beefed up our claim, which we ended up just, negotiating a very favorable settlement. So it didn't even get to that point, but that sort of beefs up that claim a little bit, because I think some of the judges, unfortunately, are still on the fence about the lead law. For a rental license and for a certificate of rental suitability, it's very cut and dry, and I haven't seen one single judge or trial commissioner even dispute that. But for lead issues, I have seen more tenants lose than win when arguing this. And sometimes a judge might split the difference and say, like, I'll forgive the rent, but I'm still, awarding the landlord possession, which is still an eviction. So I think for something like this, it's great to use as a bargaining chip and the threat of a possible claim against the landlord. The president judge currently stopped the counterclaims. So you have to file these as a separate small claims action now. The cap for a small claims action in municipal court, small claims court, is 12,000. But if your rent is 1,000 a month and the landlord hasn't had it for a year, there you go. So
the counterclaim point's important, and thanks for clarifying that. I would say, when we get into the practicalities, the way that I have seen municipal court play out is that you may have a very solid case on the black letter, but then when it comes to going in front of the judge, you have a tougher time. I lost a case actually once in front of a judge on the certificate of rental suitability issue, and I had to appeal it to the Court of Common Pleas to win it there. And I was young, I had a lot of time. It was like the markets had slowed down, so I pursued it. But that was a lot of work to get to the result. And it's like, I often, when I'm counseling clients on what strategy we ought to use, I note this experience because going in front of the judge, even with a good case, you're not certain about the outcome. And, I'm mindful of the fact that the system is not necessarily favorable to our client base in these matters. And so I try to help them reach a practical reality. Now, sometimes they have both, strong feelings on the thing, and the client ultimately makes the call on which strategy we're going to actually go with. I just do my best to counsel them on what I think is going to get them the best result. And so, as Tom was saying, even if you've got these defenses, I would caution you against ever telling the client that this is a knockdown, drag out, a win for us, because the reality is it's not. And you may yourself, spent 200 hours prepping for, your first municipal court trial because you're not you're a transactional lawyer and you don't know what that's going to look like. And then ends up being a 20-minute hearing. Okay. So moving on, we're now kind of, yeah, of course.
In addition about the rental license, examine the rental license carefully. I have a case now where the rental license was for one unit and it was a duplex.
Mm.
I argued that the rental license was invalid. Unfortunately, the court appealed it.
Yeah, and what a good point. So in case folks didn't hear at home, check the rental license, because sometimes people will only get one unit in a duplex certified, or maybe originally they were living in the other unit and then they changed their mind and decided to rent it out, right? That's a really kind of common thing. So you should make sure that the rental license covers the entire demised premises. That is great. And thank you for that. So now we're going to get into kind of some of the common law defenses. And so the one we have to start at, and the one you're going to hear the most of from tenants, are breaches of the implied warranty of habitability. So there is a Pennsylvania case called Pugh versus Holmes. It was decided in, I think, 1978, but still good law. And it just basically says that, if you are renting out a property, you have an obligation as a landlord to maintain safe and habitable premises. And if the landlord breaks that obligation, the tenant doesn't have to pay rent for the kind of portion of the premises that are not safe and habitable. How this actually, plays out in court is a little tough. This is probably the issue that we spend the most time prepping on, and one of the ones that's just the most uncertain and difficult to kind of prove in front of a judge and really win on. And it's a real shame because, a lot of the time when you're talking to tenants, a lot of what they've suffered through and a lot of the complaints and maybe a lot of the reasons why they stopped paying rent is because literally there are real material problems with the property. I had one client who had one electrical outlet in the entire apartment that was working. Another one, like half their roof had fallen down in their bedroom. And, you know, it is just a real tragedy. And here's the problem. Like, you might not win on reducing the rent on those claims at all. And so it's, you know, we'll give you best practices on how to establish those defenses and make them as persuasively as you can. But, you know, this is one of those where in negotiations, the landlord and their counsel are going to be just like the most dismissive you've ever seen another human being be. And it's really something, though, that you've got to lay out there because, you know, you might be, of all the ones, you're probably going to spend some time talking about this in front of the judge. And you want to make sure that when you come to court, you're well established. So how do you establish this defense? So one thing that tenants can do, and I mentioned this a little bit earlier, is file a complaint with L&I. And if L&I comes out and inspects and says that there's a problem, there will be records and evidence on the property. And you'll see this is a screenshot on the screen right now from the L&I website. You can search for the property address. You can get a history of the investigations and the licenses and the permits, and you can get what's currently outstanding as a violation. So that's that if L&I has come out and has given that there's a violation, very persuasive. Also might, you know, be grounds for other reasons to withhold and prevent rent, but very persuasive. Now, the problem, L&I is understaffed. They don't necessarily show up to the appointments that are made. They might not be able to give you an appointment for like 3 or 4 weeks. They don't respect your work schedule. If you are someone who, you know, has a 9 to 5, or like you work a job where you literally cannot take time off or be away from where you work, it can be really inconvenient to get L&I to actually do the inspection and get the evidence. So while it is compelling, it is also very difficult to actually effectively utilize L&I as a solution. So then what do you do in that case? I personally will prep a binder of photos of the issues and have them ready. I bring them in triplicate. So I have 3 binders made up. I print out a copy for the judge, the other side, and for our side. And, you know, the photographic evidence of the damage, like the collapsed roof. Some stuff is difficult to kind of photograph, like if there's only one electrical outlet working in the entire building. You know, or if the carpeting is like, you know, soaked all the time because of a water leak somewhere, maybe you can get evidence of the water leak on the walls, or you can show the pipe. But, you know, the point is you try to get the photographic evidence, you try to show the damage. And then the other thing that I will often do is try to assign a value to the damage and then use that as a claim. The claim is, you know, for rent that has been paid, I will make a claim for overpayment of rent based on the habitability issues. And I think that's the right way to do it. I'm just not, hopefully, it doesn't go in front of the judge enough for me to know. But I'll make a claim for overpayment of rent in terms of the damages, and I'll have a chart that lays out what the issues were and then the amount of the reduction in rent. And there's some art to this, and there's a bit of a bid ask. Again, going in front of the judge with this is seldom enough that, you know, I can't give you great practical advice from reality, but I don't try to ask for the moon. I try to be reasonable and give a good faith estimate of the actual damage and habitability. You know, things like if there's no heat, no water, those are huge. If the kitchen's not working or the stove's not working, that's pretty big. The electrical outlet was actually like pretty persuasive at why it's stuck in my head. The collapsed roof too, like those sorts of things can be really material reductions in the rent. And then you say, look, I'm happy to here's the damage, here's the time, here's our documenting evidence, here's the emails we sent to the landlord or the text messages we sent to the landlord with date stamps showing when we informed them of the issue, so they knew. They did nothing. They never sent anybody out. We did complaints on the landlord tenant portal, all of those things. And I have that all together in a binder, and I say I'm happy to take this in front of the judge. And maybe it's a bit of a tactic, right? Because we all know we're not likely going in front of the judge, but I'm ready, and I'm showing that I'm ready. And what I want to kind of back up what my ask is. Do you guys have any other practical?
Yeah, I'll say I agree 100% with what John said about how opposing counsel and landlords are typically pretty dismissive when you bring these issues up to them. This is also the thing that the bulk of your clients will bring to you as their main concern. And a lot of it, in my mind, centers on a breakdown in communication, where a tenant has been living at a place and maybe there's been like a leak in the roof. Maybe it's like a small leak, but it's like an annoyance. It's in the child's bedroom or in the bathroom, and it's kind of disruptive to everyday quality of life. And the tenant has requested, 3 or 4 times over the period of a year to have it fixed. And the landlord is kind of dismissive of it. And then the second the tenant is late, the landlord files in landlord tenant court, and then the tenant's like, well, what the heck? That is something that would not rise to a breach of implied warranty of habitability. These are a lot of cases are a lot of these kind of issues are things where you look at it and you go, okay, the property is not up to like what it should be, but is it enough for a judge to say that you shouldn't have had to pay rent for that entire period of time that the landlord is suing you for? This is kind of like one of those things where like it when you see it. So like John said, no heat in the winter. That's like a textbook definition that, like you would teach a law school class. No heat in the winter, no working water. If like the sewage pipe is leaking in the house, that's another example, but these are very tough to win. I like that Kate put in this slide, the tenant should escrow rent. The tenant is not required to escrow rent under that case, Pew v. Holmes. However, they totally should escrow rent. So that's a great point. And the reason they should escrow rent is because it goes to credibility. Because if this does go in front of a judge is going to weigh it and go like, all right, well, why are you still living there if it's that bad? That's what almost all of them say. If it's that bad, why are you still living there? But the reality is that a lot of our clients, a large portion are single mothers with children. So, the kids go to school, they're kind of settled in. It's not easy to uproot, you have 2 or 3 kids and take them to a new school. So if you're escrowing rent, it just shows that you're doing this for a legitimate reason. If you're escrowing rent and then you also paid out of pocket for a repair and you keep the receipt, you're in a much better standing. I would never personally advise someone to escrow rent for a habitability issue. I always advise against it, especially if you have a Section 8 housing voucher, because the risk of you losing your voucher and then having to go back on a wait list, which could take years to save a little bit of money when you should try and just work on a move out. It's just the risk to reward is not worth it in my mind. So this is a tough one. I think we lose much more than we win on this one. And I advise against it unless it's absolutely necessary. Like if the tenant absolutely cannot pay rent, sure. The thing with escrowing rent too is that many of our clients, given their financial situations, if they can escrow rent, they're going to need that money for something else in the next month. So it's probably going to disappear. And judges always ask about escrowing rent. So it just puts them in a much tougher spot.
And the other thing is, when we as volunteers get involved on these cases, very often it's kind of been escrowed or not, right? You're just there, and the facts on the ground are the facts on the ground. The other thing is about the habitability issues is, they're going to surface in the middle of other problems too. So for example, I was living with the one electric outlet, but the real reason I stopped paying rent isn't that. It's because I lost my job. And, they're all so interconnected, and problems breed complaints and vice versa. So, it's kind of holistically understanding what's going on, and the habitability issue, addressed or not, may not fix the fundamental problem, which is the client can't afford to be in that place anymore. And until that gets resolved for the client, the habitability issues while terrible, aren't actually going to, even fixed, it's not going to solve the problem. So you have to keep that in mind as well, when you're kind of talking to the client. It's can be, additional help in terms of negotiating and showing your seriousness to the other side. And, when we get into strategy for working with landlords council, we can talk about that some more, but, just keep it in mind. This will be the one you spend the most time on, and it's the one with probably the lowest hit rate in terms of like, I got a great result. But that, at the very least, even if you didn't win the case, you did something for the client, and hearing out their problems and letting them vent the frustration of having another human being acknowledge how terrible the situation was for them. You're doing a good there too. And even if you can't vindicate their rights on that point, you at least made them feel heard as a human being, which I think is a really kind of important and critical part of these representations. Is you're not just doing good legal work, but, helping human beings and feel connection to community and to each other, and being felt as heard.
I could totally agree. That I think is the most important part of this job, because so much of the breakdown, or the frustration, because your clients are going to be frustrated when they're in landlord-tenant court, and they feel like they're being told they're a bad person, or like they're just blowing off rent, and that is almost always not the case. Like John alluded to, a lot of them, fall in hard times financially. It's tough you're a single parent, which many of our clients are, kind of just validating them. I mean, I think as lawyers, we're called counselor for a reason. So I think, you get a client, the first 20, 30 minutes on one of these cases is going to kind of be being a therapist, essentially, and just listening and validating them. And then I always, anytime, especially if you're going to work out a settlement, I think it's always good to come back, and if the landlord is open to having the tenant stay there and work out a pay and stay, I always say, look, they seem to like you there. You're a good person. Things kind of broke down, but they clearly respect you. I always try and say that because there's like a human aspect to this where they feel like they're being kind of pushed aside and just looked at like they're doing something criminal, when really it's just, kind of life just happened and things spiraled. And in many cases, they communicate and that communication isn't met. So that's another source of frustration. So I agree, the most important aspect of this job, which is something that prior to becoming a lawyer, I don't know that I anticipated, but it's crucial.
Yeah. And a pay and stay where you also repair the relationship and maybe even reduce the amount that has to be paid is like a tremendously good result, right? Like they're still paying the back rent, but this is a contract. It's something they agreed to. And like, if they're able to make good on that, then, we've got everybody to a win-win, which kind of are my favorite solutions in situations. And people very often feel really good. Both sides feel good, and maybe they don't feel as good as they could, but both sides end up feeling good. And that can be a rewarding result too. So let's talk about this. I don't know if we want to be interactive or not, but we have up here an example case that, is this based in reality, or is this synthesized? All right, so this is synthesized, but it's a good, it's a good fact pattern. So you'll see a couple of the highlights in here, but I'm curious as people take a second to read through it. I hate to like cold call on people, but and we'll be able to volunteer. But does anything in this list stand out to you? And does it give you any ideas of things you can ask a client about in terms of better establishing this implied warranty of habitability defense?
The exact amount of time the heat was out.
Okay, great question. So I like that too. When did it start? Was it before November? Was it in October? Like, that's a really good one. So the exact amount of time the heat was out. On the heat issues, any other ideas? One thing oh, go ahead. Yeah, that's one I look at. And if you have a receipt too, right? Because that's a cost. If heat is supposed to be provided under the terms of the lease, and I had to buy a space heater to be adequately warm, That's a cost. I can put that down and I have a receipt there. And I can say the heat was out. I complained the heat was out as of this date. I bought the space heater on this date. I paid $200 for it. I'm going to say reduce my rent by my back rent owed by $200 because that's a real cost. The other thing is I like to look at the electricity bills, especially if there is if the electricity bill is relatively higher compared to what it was that same month in the last year. Because like, not only did I have to pay for the space heater, I had to pay for all the power for the space heater. And you can see I paid $30 more for my electricity this month compared to last year. So, real costs that are real demonstrable and, have a basis in evidence. It's not just me guessing on what the market value of a collapsed roof is. I really like that one. Yeah, precisely. And, one thing about how these properties are managed.
Could you repeat the questions for those at home?
Oh, sure. So, Willie, what Willie had said, so the question was, looking at this, does anything stand out to you in terms of how you would establish, or the questions you would want to ask the client in terms of establishing the implied warranty of habitability? And so on the heat issues, Willie first pointed out, when did this start? And it's an important question. Especially if it started in November, and that's why we ceased paying rent in November, right? Because then that adds some credence to the argument that we're really withholding the rent because of the habitability issues. And some other things that we noted are, you have a record of when the space heater was bought. You can have a record of how much the electricity bill increased as a result of using the space heater, and those are really helpful. Okay. Does anybody else have any other ideas on the heat issue before we move? Because there's a lot going on here. Okay. What about the water leaks? Oh, there was one other point I was making is a lot of the way that these properties are often managed these days is that there is a website portal where the landlord and the tenant interact. And so if the tenant has a maintenance request, they usually submit a ticket on a portal. And you can get usually there's email confirmation or records of your tickets on the portal. And so having access to that portal or having printouts or screenshots of what's on that portal can be really helpful as evidence in establishing a track record. The other thing I'll note is a lot of times landlords and tenants text each other these days, or like text the property manager. And so having those records as well can be super helpful. Now it's a lot to dig into. Discovery is not my strong suit. But like you come to a pile of text messages, you can highlight the important ones. And the tenant can help you with that in terms of like picking out what the key moments are. The water leaks upstairs in the bathroom and in the kitchen below. If you can get pictures, that would be helpful to know. And, if the leak is ongoing, you can still kind of take the pictures. You can show the water damage on the walls. You can show where the ceiling, maybe when the leak is passing through. You can show a picture of the electric fuse box. You can show pictures of the mold mildew issues. We're not hiring experts to come in and test the mold or the mildew. I have never, I've seen mold and mildew a bunch in these cases. I've never actually gotten anybody to do anything about them, even though they're very serious and can cause respiratory issues and the like. And all right, what about the rats and roaches? Any ideas there?
Take pictures, possible.
Yeah, I mean, if the infestation's bad enough, pictures of the rat king in your house, that definitely helps. Very often, I have found that tenants will pay for like extermination services or buy traps or buy those sorts of things. So receipts for that, I think, can be really helpful. Complaints and then the landlord saying it's not our problem, when I think it generally is in terms of habitability, especially if the rest of the pictures in the apartment show it's kept in good order, but there's still a rat issue, so it's not even originating in the unit. Those can be pretty persuasive. You'll see here the like many maintenance requests. So getting those and when and the timing are really important. The thing I'll say is sometimes these maintenance requests play out in a little more of a nuanced way. So like I put in the maintenance request and they show up and then they spent like $20 fixing the problem, but it didn't really fix the problem. Or they had, your regular handyman come in and he like put some duct tape on it and was like problem solved and then left when really you needed a plumber or an electrician to come out and really fix the problem. So it's like, just understanding who was there and what was done. And, the one thing is I have found that the client base in the program are really good at sussing out who's actually qualified to fix a problem and who isn't, and whether that person was actually helpful or whether they were full of it. And, listening to them and getting that information from them and then finding ways to best present that can really be helpful. The 9 open violations on the property is a big deal. And, depending on the severity. Now, not every violation is viewed equally. And I actually am not sure, like, how do you guys have insight on how L&I classifies the violations and which ones are like the big ones from their perspective?
No, and that's one of the issues is when you go on the website and you click on it, a lot of times you just get like an abbreviated 2-sentence bullet as to what the violation is.
It's like the violation would be like elevator failure compliance or like fire hazard. And it's like, what does even that mean? And how do I assert that? So it's like, it can be tough. But looking into the website and reading this stuff, what about, do people have thoughts on the landlord did not give enough notice beforehand? What do you guys think about? How do we think about that one? How do you look into that?
You check the lease first.
Precisely right. So you to figure this one out, you've got to know what's in the lease in terms of notice. And the common way I've seen this play out is a landlord is selling the property and they want someone else in, or they want the tenant out so that they can sell the property without a lease in place. And so they're looking for any excuse to get the client out. And maybe even like taking worse care of things and like not remediating issues because they're really trying to push the client out, even though they've got a lease for, another 6 months or whatever. So paying attention to that sort of thing. And like this kind of stuff can be the ground for you kind of establishing what the story is and what's going on. So you have a narrative and like talking to the client. All right. So why were they trying to get into the apartment? Oh, they're looking for the next tenant to come in, but like, is that 6 months from now? That seems a little early to be leasing. Do you know, like, and then like, they'll tell you, they'll like, oh, so-and-so said they were selling it, blah, blah, blah. You get that information you might not necessarily see on the face of the complaint. And that can be a helpful tool for understanding where the landlord's head is at. If the landlord is selling the property and they're desperate to get the tenant out, you've got a little more leverage in terms of the kind of deal you can take. Maybe you can get the rent further reduced, even lower, maybe to zero, if you're promising to get out in a short period of time, or get a little bit of extra time because the sale's not closing for another 3 months. So you can have 2 months to get out and they still have enough time to kind of clean up the place and do what they need to do to sell the property. So, it can not only does checking into these kind of habitability issues, are they helpful in and of themselves, but they also can kind of give you context to understand the kind of negotiation you're in for.
I'll just hop in.
Of course.
I think this is a great example. This example that is in front of us right now in the PowerPoint, because this is a very common scenario. All of these issues, and then at the end, the client's goal is to leave the apartment and avoid a judgment against them. But she would like, a little bit of time because you can't find a new apartment overnight. So avoiding a judgment would just mean coming to an agreement with the landlord, or winning. A judgment would be if the tenant went to trial and lost, and then the judge, ruled for the landlord and said, I'm also saying that you owe a judgment amount of $2,296 against the landlord. Here, in cases like this, if the tenant and the landlord are at polar opposite ends of the spectrum and there is zero chance of working something out, if it's a case like this, I will always request a continuance and then find time to go to the property myself with the landlord's lawyer. I've only done it twice, but because, those cases were not going to get worked out. So they were going to go to trial, and I wanted to see what I was looking at. I wanted to see how bad the mold was because, number one, it would either make my trial better, or number two, it would allow me to confront my client and say, listen, this is not that deep. You should, agree to the settlement that we had on the table. I think here, the client's goal, if I had this client, I would say, I think your goal is smart and makes a lot of sense to me. And like John said, I think my goal as the lawyer would be to get that number, the 2,200 number, ideally wiped to zero, and then work out a 90-day move out date. 90 is these numbers they sound arbitrary, and they are, but in landlord tenant court, the kind of working numbers that we have for move out dates are 30, 45, 60, and 90 days. Landlords were normally asked for 30. 90 is best case scenario, which we don't get as much. But here, there are a lot of things that, look, the landlord wants to get rid of the property. They want to sell the property. So what I would tell the landlord's attorney is we have some things that we can work with here. If worst case scenario, this goes to trial, even if the judge rules for you, I'm going to advise my client on how to appeal. The appeal process takes months and months and months to play itself out. If this is a landlord that wants to sell it, agreeing to 90 days when that's certain, it is certain that the tenant would be out in 90 days, makes more sense if they want to actually get rid of the property. So both sides kind of win in that regard. So this example, if you're going to take cases like this is not uncommon. I think a good goal for this would be to reduce that number up top for as much as possible. And get 90. The other thing with that number up top too is that when you read the initial lease, you'll see how much normally you will see how much the tenant put down in escrow for security deposit and last month's rent. So you can kind of get creative. Maybe if the landlord, wanted some money, I would say, okay, as long as they move out in 90 days, mark that money is satisfied, and then the landlord keeps the security deposit and last month's rent. So then it's they get a little bite of the apple, and then, they get a little something. So you can kind of get creative with that stuff. But here, I think the goal will be to give the tenant some time.
As a practice tip, the security, go ahead.
This is Joe Tate. Going back to what you were talking about with L&I, since we know they're overwhelmed, do you know if L&I keeps track of the number of phone calls that come in so that you could still say to the court, look, here I have a record of 9 phone calls and L&I has yet to respond to us?
I have never successfully gotten L&I to give me a single piece of information myself. I think that if I were establishing that, I might show the phone records from my client, but it would probably be screenshots of the L&I number repeatedly from their phone over time. Have you guys had a different experience?
No, I've had more luck just having my client take pictures or videos of the issues. L&I it's sometimes, very rarely, but sometimes they will put strong language in the report or say something about how it's imminent harm and the building needs to be or should be condemned, but that's rare. Normally, unfortunately.
Is there any L&I record other than a violation? There's no record of calls.
No record of calls or complaints.
Not that I'm aware of. No, I don't think they document calls. And if they did, the amount of time it would take us to get them, because the turnaround on these court dates is so short, you're looking at 3-4 weeks. I think it would be impossible to get those in a timely fashion if they even did exist, which I doubt they do.
And even if you get a continuance to give more time, you're usually getting nothing more than a month and sometimes less. So, it's really tough to get a strong evidentiary record on all of this stuff. And then you have the other problems that the client might not be there when L&I can show up, and they don't give you any firm timelines. They just are there suddenly. And whether you have a work shift or not, you wouldn't know. And if you don't answer the door, they're just okay, visit done, I'm out of here.
The other thing with calling L&I, if a prospective tenant calls me and they are not in landlord tenant court and they're just paying their rent and their habitability issues, like I said earlier, I always say I do not recommend withholding or escrowing rent. And then when they ask about L&I or Fair Housing Commission, I kind of say like, look, things are going to get a lot more hostile between you and the landlord if you call L&I. Like no landlord, that's not going to be something that a landlord will be thrilled about. And there's a power imbalance in the relationship between a landlord and a tenant. So, you know, if you go down that route, and then you're late one day, you know, and or you do one minor violation of the lease, you let a guest stay 4 nights when it says you can only have a guest stay for 3 nights without other permission from the landlord. You know, do you really want someone kind of watching you like that? In my mind, look, if it gets to that point, it gets to that point, and you have to. For me, in terms of like my roof over my head and my housing, I'm a risk averse person. So I kind of give legal advice based on that. And if you can slowly find a new place to move into before things break down to that point, I think that's ideal. But, you know, if it gets to that point, you have to call L&I and document it yourself. And then I think it was Tiana that asked in the chat about were the maintenance requests made in writing. That's you have to do that. That's the other thing with the reality of how many of our clients live too, is that, you know, you take like, for example, like a common client, a single mother with multiple kids, they might make that request in passing to a property manager or a maintenance person once. And this is one maintenance person that probably oversees like 7 different buildings, and it's in one ear and out the other. And this is someone that's so busy because they have 2 jobs and 4 kids that they can't follow up in writing all the time. So the reality is it might not be in writing. That's not uncommon. So these are, that's why I say all this to say that these are very tough cases to win. So like if I had a client like this in this hypo that wanted to, you know, use all of this to avoid a judgment and work out a vacate date, I would say, I think that's smart.
One thing from the chat, and then we should probably also read out the CLE code.
Yeah, I was thinking that too.
But Elizabeth in the chat just said to circle back on that thing. Ask for supervisors when you call the L&I offices. They work exclusively in the office and can check the records of complaints. They also have emails which can sometimes help with responses.
So hopefully everybody heard that at home, but Elizabeth had a really good tip, which is ask for supervisors at L&I. And they work exclusively in the office. They have access to the records. They can get you information. So that's a good one. I'll try that on my next case. And then Willie, what did you have?
So recommend that my clients contact L&I through the website. You can actually make a written complaint online, then you have a record of the ticket and tracking of it.
So William points out clients can make these L&I complaints on the website, and then you have a written record of that sort of thing. So maybe in connection with a continuance strategy where you're building out a little more time to establish things, and like things are very, you know, clear, you know, you can hopefully use that as an opportunity to kind of bolster the case. Again, the habitability stuff is not something I have had tremendous success on, but if it's a serious issue, it's worth pursuing because it could be the difference between your client having to pay that $2,296.75 and being out in, was it 21 days if there's a judgment against them, or you know, them being able to, you know, take that money and use it to get a new place to be, if that's really their goal. Cool.
I'm going to read out the first code. All right, everyone. So the first CLE code is COL, all caps, 418. That's COL space 418.
Great. And so at the end, so we're nearing the break. And so at the end of the break, do we have to sign out and then put that code in and then sign back in?
It's saying to,
I think everyone should put this in at the end of the entire training. I don't think we need to sign out for the break.
Okay, great.
There's going to be another code.
So there should be a space for 2 codes. Okay. All right. Well, so that's the code for the first hour of credit, and that's for everybody. Let's move on to, this is kind of like the less common defenses and the kind of grab bag. So we won't spend as much time on these, but they're things to kind of keep an eye out for. The first is eviction for good cause. For any lease that's shorter than a year, the landlord can only evict you for good cause. So it's unclear whether this applies to leases that have converted over to month, but you're certainly free to make the argument that there was no good cause for this. Very often, the landlord's in court because of non-payment of rent. But if they terminated the term of a month-to-month lease, that's an issue that you've got there. Like, I've been paying every month. What are you doing? So that's something to keep in mind and an argument that you can make. Excess security is I wouldn't say it's uncommon, but it's just worth kind of keeping in mind because it's one of those things you can use to reduce the number. A lot of landlords will require that you escrow last month and security deposit at when you start a lease. The issue is that after the first year, they're only allowed to keep a security up to 1 month of rent. And so if they have 2 months escrowed, in a technical sense, they are breaching, or in a literal sense, they're breaching and having excess security on the lease. And so that is a direct claim that they're holding more. Technically, the client's also entitled to interest on those amounts, although I've never had any good success on getting interest on excess security escrowed. But it can be a bargaining chip to reduce the number. Kind of another practical point is that I have had real great difficulty getting landlords to ever return security deposits. And to me, if they've got the money in their hands, in your mind, you should think about that as like a bargaining chip that is just, because even though a landlord's failure to return security deposit is subject to like treble damages, I've never actually seen anybody successfully pursue that. I don't know if that's been your experience.
Yeah.
And very often they're required to return the security deposit and they never do. Like, and so and the tenants just then eventually give up. And so what I'd say is, like, when you're negotiating these, like, having the security deposit, like, I'm not paying any more money out of pocket, but they keep the security deposit and I get 90 days to move out and I'm not paying the rest of it. Great result, because that security deposit's gone. Like, you're not getting it back, at least in my experience.
No, I've had the same experience. It is a great bargaining chip, though.
Yeah. And it also gives, at the very least, like, when we talk about strategy, it gives the landlord's lawyer, like, we got you something, even though everybody knows that amount was ever going. So a legal lockout is what it sounds like. There's no self-help in terms of evicting tenants. They can't change the locks. They can't put padlocks on the property. If they do that, that's a big breach. I've never seen one of these. Do you have any experience on how this plays out?
The only experience I've had with these are, I've had one with locks, and then there's also the functional equivalent of an illegal lockout where, like, they cut the utilities. That I think is a little more common, like they shut off the water or electric. That's considered an illegal lockout. You can actually file a claim in small claims court if a landlord does that, and the statute permits up to $2,000 per violation, and violation is each day that it occurs. So, you can normally seek the max in small. If that happens, I would use it as a defense, but I would also advise the tenant to file something in small claims court, because that's pretty egregious, and it's one of the few things that I think all judges would kind of acknowledge.
Can you also talk about FHC, Fair Housing Commission?
Sure. So Fair Housing Commission is kind of similar to, I guess, calling L&I. It's a similar kind of thing. If, a landlord has breached the implied warranty of habitability, or if they engage in a legal lockout, there's a massive hole in the roof and it's leaking snow and rain in the winter, you can file something with the Fair Housing Commission. The Fair Housing Commission is its own separate entity. It's a city organization that can order the landlord to make repairs, and it can also fine the landlord and make them pay money to the city. It can also abate a period of the tenant's rent, or make an order about that. The two things to note about the Fair Housing Commission is that if a landlord files something in landlord-tenant court, like, let's say the tenant is currently facing an eviction hearing coming up next week in landlord-tenant court, that tenant cannot file something in Fair Housing Commission, because landlord-tenant court kind of overrides that, so that they wouldn't entertain the complaint. Fair Housing Commission, it, like, can kind of validate what tenants are experiencing, and the Fair Housing Commission, in my mind, is a pretty fair and favorable forum in that they listen to the facts. I think a lot of these arguments that I've been a little pessimistic on do work in the Fair Housing Commission. I've seen that happen, but the Fair Housing Commission just doesn't have as much teeth to it as municipal court does because, like the fines are, they'll order a landlord to pay fines to the city, or they'll order a landlord to make repairs. And it's just like, if they don't, okay, they don't. And that's kind of something that like the landlord will have to deal with on their own, but how does it impact the tenant or help the tenant? And the thing that I always say about calling the Fair Housing Commission is that once you do that, you will have a microscope on you, and the relationship between you and your landlord will have deteriorated to a point of like no return. And it's tough, I think, for tenants to like, it's easy as lawyers to look at, this stuff and give advice on that. But like when you're living under a microscope from someone that has control and power over your housing, it's not someone that you want to be hostile to you. So I think it's something that, if you're escrowing rent and you're making repairs and you're still paying your rent and they're not doing anything and you can't leave because you have 3 kids enrolled in school, it makes sense. But again, in an ideal world, if you can just find a new place to move to, and not all landlords are like that, where they're just going to blow things off. But that's the Fair Housing Commission in a nutshell. They do issue orders. Sometimes if they issue a favorable order and then 2 months later, the landlord files something in landlord tenant court, you can use their order in front of a judge in landlord tenant court, which is helpful.
Is there an easy way to access any orders issued by the Fair Housing Commission, or is that something you have to get from the client?
They, the one time I had it, they sent it to municipal court. So it was very easy.
Got it.
And my client had it as well. Most of the clients that go forward with Fair Housing Commission are very good historians, and they document things very well. And the nice thing, I like the Fair Housing Commission. They issue very strong orders. They spell out the facts. They take it very seriously. It just doesn't have as much teeth to it as like the client winning something in small claims court or winning a landlord tenant case. And oftentimes like some of the penalties that they impose on the landlord are just things that the landlord face and don't necessarily like help the tenant. And the way I always frame this to my clients is, I get your frustration, but like I'm more concerned with keeping you out of trouble than I am getting your landlord in trouble.
Right. So I haven't ever had a case where there's been FHC involvement. So, this is helpful for me too. But a good thing to keep an eye out on. And, one thing is if you're encountering a rare or weird issue that you don't know how to deal with, you can reach out to Philly VIP or to other experienced attorneys who have done this stuff to help you. And they can at least point you in a direction and get you to resources. Because, we all share kind of the common goal of making sure that we give good representation to these clients. And it's important to when you're doing your job as an attorney, to know when you're in over your head and call for help. So the next is notice to vacate. This is a little simple. It's just like there's a requirement. I think it's 30 days prior to the actual like attempt to evict. They have to give you notice to quit, I think it's called. Normally that's filed as part of the landlord tenant complaint too. And a technical breach of it is, means that the complaint wasn't validly served. And if it wasn't validly served, then what are we doing here? This is one I've never seen actually like successfully knock out. At the worst, maybe it could toll slightly. But, it's worth keeping in mind because non-compliance means they didn't meet their burden and all of that stuff. And, you can try and make the argument. Practically speaking, I don't think, I don't think you're winning on it, but it's good to have in your back pocket and gives you additional kind of help.
That's, I think, to John's point, a great way of looking at all of these things that we're pointing out. When you have to go to trial, you're probably going to lose. But if you have something that you can say to at least, make a good faith argument, make a colorful argument, and have your client feel like someone advocated for them. At the end of the day, if they feel like someone fought for them, I think that's a win. So if you comb the complaint and if you argue something on the notice to vacate, which is a legally sound argument, whether a judge wants to honor it or not, sometimes if a landlord really digs their heels in, which a lot of pro se landlords are the most difficult people to negotiate with. Sometimes you'll go to trial with them just because they'll say things like, I want them out in 10 days. And you're like, well, what,
Yeah.
it's like some of them, it's like hard to even have a conversation with. So, if you have one thing you can say, it's better than nothing.
So retaliation is, that is, textbook cases. You filed a complaint with FHC or LNI, and now suddenly you're finding yourself facing an eviction. You did something you were allowed to do, and the landlord is now retaliating against you for doing it. I'll say I don't have a ton of experience with retaliation cases, but it's just something you assert as part of the process. And if the facts support it, it's a good argument. But it's, again, as Tom was just saying, I think it's part of building the case and advocating for the client. It is tough to win on the issue. I don't have a lot of experience with domestic violence issues and cases. Can you talk about that one, Tom?
Sure. I actually don't have any myself, but there is a carve out in the law that gives a victim of domestic violence who's on a lease against, with a domestic partner, if they, follow a couple steps in terms of reporting the abuse to the police, obtaining a PFA, and then notifying the landlord. There is a period of time where they are protected from an eviction proceeding taking place against them. This one's tough. It's really nice that there is a law like this, but it's a lot of times tough for domestic violence victims to meet these requirements because it's so chaotic. There's like so much going on. You're being victimized by someone that you're living with, and meeting all these reporting requirements, and then notifying the police, your landlord, and then sometimes it's like that person just wants to leave themselves. So it's tough. That's why there are like a few things that have to align themselves before you can even like assert this. So that's why it doesn't come up that much, but it's good that there is a carve out in the law for that.
So we're at basically 11 now. What we have scheduled a kind of 10-minute break. So I was thinking maybe we could pick up the EHPA, which I think is expired, but then maybe spend a little bit of time on the eviction diversion program, because that's a relatively recent development and is still relevant and active. And then we'll talk about kind of some practical tips on representing a client in landlord tenant. All right. Hopefully people can hear us, and now it's actually 11:10. So in the last 50 minutes or so, we're going to just get into one more defense, and then we're going to talk a little bit about the nuts and bolts and practical tips on representing a client in a landlord-tenant matter. So the last thing, and some folks actually in the room have experience with this, is the eviction diversion program. We previewed this early on, but the eviction diversion program was introduced in during the COVID period. It creates a mandatory requirement that landlords and tenants try to go through an eviction diversion process, and has a kind of period of time where the landlord is supposed to negotiate in reasonable good faith to resolve the issue. One thing that I have found is that some landlords are resisting this requirement and, not complying at all, or having a very hostile call with their lawyer, and where the call is effectively, "I'm not doing this," and then hanging up on the client and saying, eviction diversion complete. That does not, in my mind, meet the standard of reasonable good faith negotiation. And so having that in your back pocket as another helpful defense can be an aid. The program gives the compliance with the requirements of the program, give the judge substantial latitude. And one point that Willie was making in the break is that, the judge that you draw in your landlord tenant case can make a substantial difference. Some judges are way more favorable to the tenants than others. And some are going to be, quite skeptical and hostile on any kind of claims that you make. But failure to comply with the requirements of the eviction diversion program is another defense that you can assert. And it's one that landlords have been falling down on, like they used to do with the certificate of rental suitability. Tom?
I agree with all of that. And in terms of the landlords being required to participate in the eviction diversion program, they're required to show proof of that participation when they file their complaint. So there are a few things that they are supposed to attach to their complaint when they take a tenant to court, and proof of the eviction diversion program, participation in the eviction diversion program is one of them. It'll be a document that'll have an EVP or an EDP number, like EVP-6234FW or something like that. You can copy that number and go to the eviction diversion website and paste it in to, verify for yourself that, number one, the landlord did participate in good faith, and number two, like it's a legitimate number that corresponds with that landlord and that tenant and that property. If I know that a case is definitely going to go to trial, it's something that I'll double check, but they are required to like John said, good faith participation. And when I've had to argue this at trial, I was unsuccessful, but I think using the policy rationale behind all of it is helpful if you're going to use this argument in a hearing. Like, this is a program that the city created to keep people out of court so that the court system wouldn't be overburdened, and so that tenants could keep roof over their head and landlords could keep getting paid. The city, gives landlords thousands of dollars to pay off arrears, and for them to not participate in it and try and circumvent that goes against everything city council intended. So, it's another thing you can argue if it gets to that point, but it is a great program. A lot of times it does benefit the tenant and the landlord to work things out.
Totally. I have had some success on this issue, but maybe it was, I was pretty offended because if the landlord had just hit send on the application, then some of the funds available would have paid the entire back amount. And I was showing on my face and body a complete willingness to go in front of the judge and try. And then lo and behold, just before we got to a result that was good for the client. So, it is one of those things to like pay attention to and really like think about. And in my case, like the landlord was there and literally said, I don't have to comply with this. And I was like, okay, that's a great thing that you have said. And I said nothing more at the time. So let's move on to kind of, this is the notice that Tom was mentioning they're required to give. It's hard to see, but you'll get a copy of this presentation. But you'll find the EDP number on the complaint or in the files attached. So let's talk about representing your client. Kind of like before. So you can go to Philly VIP's website. You can find what cases are available and what timing, and kind of get an overview of what is going on in the case and what the possible defenses are and the situation is by going to their website. You can search by landlord tenant options and you can see what's available for what dates. And it's a really good resource and your kind of starting place. If you are interested in a case, you email Philly VIP at the contacts that they give, and you get the information. So, my experience is you get the information you need to run conflicts. These are real clients. You have to make sure there's no conflict of interest. You get information on the tenant, you get information on the landlord, and you run that through your kind of conflicts process. After you get through your conflicts process, whatever that is when you can request the full file and get all the case materials. That can be intimidating, especially if you're like, a first or second year lawyer, because you're like, how do I run conflicts? I promise you, at least, my experience here at Dechert, it's not that hard. And, if the partners at the firm have to do it all the time, then you can believe it's probably streamlined enough that it's reasonable to accomplish, even if you're brand new. So, and internally, if you're a Dechert lawyer and you want to know about it, I'm very happy to talk to you about it. But every place is going to be a little different. Just keep it in mind. You ask for the conflicts materials, you run conflicts. When conflicts is cleared, you let VIP know, and then that's when they send you the full case file. and all the stuff you need. At the time you clear conflicts as two, VIP will tell the client that you've been assigned, and often they'll give you the client your contact information. So all of that is just to say, when you do take a case, know that once you've got the file, the client has your name and may reach out to you. So what I'd say is, like, when you're ready to take the case, read the file pretty quick, because you might be getting a call from the client in like that day, because they're going to be eager to meet you, to know what's going on, to know what the plan is. And so be ready to review your case file. So that's kind of practical preamble. Anything to add on any of that, Tom? Usually on the other side of it, right? So it's
Yeah.
like,
So anytime you find out your client ahead of time, I think it's best to call them and touch base with them as soon as possible. To kind of, a lot of this job is unfortunately giving clients bad news, and dampening expectations. Sometimes clients will come to me, or not just me specifically, landlord tenant court, with overly optimistic thoughts about what can happen because of some issues inside the property, maybe from like a Google search, or from like, somebody's third cousin telling them something. So what I like to do the first time I talk with a client is just kind of, first things first, do you want to stay there and work something out with your landlord? Because most of the time, again, they're being taken to court for non-payment of rent. They're behind on rent. The first question I ask after kind of having an initial conversation, is, do you want to stay there and work something out, or do you want to leave and move out? You just need a little bit of time. Those are really the two options. Either you do a pay and stay, or you do a move out date. Or the third option would be going to trial. But like, if you win at trial, you would stay there. So if the person wants to stay, I say, okay, great. Like, let's talk numbers a little bit. So today we're coming towards the end of September. If they're, let's say, 3 months behind, I would say, can you resume paying rent in the beginning of October? If they say yes, I say, great. Now your landlord is going to want some of the back owed rent paid off. The best way and the most standard practice in doing this is that rent will be due on the 1st or the 5th. And then another payment for back owed rent will be due on the 15th or the 20th. In my mind, I think the 5th and the 20th are best, because sometimes people get paid in the beginning of the month, and there might be like an issue with the paycheck clearing on the 1st. So let's say a client is 3 months behind in rent. I get them today. We have court in a week. I would say, can you pay and they want to stay. Can you pay October's rent? Yes, I can pay that by the 5th. And then I would say, okay, your landlord is going to want some money in the middle of the month, for the back owed money. Can you do 400 or 500? I think what I've seen a lot of landlords, attorneys, like that. If you go to court enough, you'll see that there are like 4 or 5 main attorneys that you deal with, and you kind of know, like, each of their preferences. One of them almost always prefers that any settlement agreements his clients enter into get paid off in full within 6 months. So if the client owes, $3,000, 6 months, I guess that would be $500 a month in arrears. If it's somebody else, maybe, or if it's public housing, you can drag it out longer. Public housing will give you normally 24 months. So I think it's good to kind of talk those numbers out with your client. If they want to leave and they want a little bit of time, I always say, like, okay, I think a good goal would be to try and get you 45 or 60 days. The landlord might ask for 30. If it's if your client wants to move and they want to do a move out date, and they need a little bit of time because it's a weird market right now to find a new apartment. If it's the very first listing, and you contact the other lawyer, the landlord's lawyer, and they are like, we'll only agree to a 30-day move out date. And your client needs more time than that. If it's the first listing, you can just show up to court and ask for a continuance. The vast majority of the time at first listings for these cases, the judge will award a continuance. And the vast majority of the time, a landlord's lawyer will not even argue against it, because it's kind of like an unspoken rule that everyone gets one continuance. Pro se landlords sometimes can be a little difficult, but most landlord attorneys are fine with the continuance. That will buy your client an extra 3 or 4 weeks. And then at that point, then you could enter into a 30-day move out date, which would, functionally give them 60 days. If they're also just like in shock and they have no clue what to do and they're super indecisive and they can't make a decision, you go over those two things. Okay, number one, we try and work out a pay and stay, or number two, we work out a move out date. If they're unsure what to do, we say, okay, we can take a continuance in 30 days. You need to come back here and have your mind made up. The alternative to doing those two things is fighting and going to trial against the landlord. If you lose at trial, number one, that is an eviction on your record, which is not good for securing housing in the future. And number two, when a judge rules for the landlord, an eviction can happen in 21 days from the date of that judge's verdict, which is much faster than a typical move out date would be. There are some things that are kind of up in the air with the sheriff's office right now. So like it is taking much longer than 21 days in most cases. However, it could be as fast as 21 days. And again, having an eviction on your attached to your name when you're looking for places in the future is not ideal. And I think that's something that a lot of people are understandably fearful of. So most people want to work something out. So it's just kind of breaking it down because it's very straightforward. Are we doing a pay and stay, ongoing rent on the 5th, arrears on the 20th, or are we working out a move out date? And then kind of, there are some nuances to that. Like if you work out a move out date for, let's say 60 days from now, your landlord sued you for $2,500. Can we get that number reduced a little bit? Or is the tenant going to carry a $2,500 judgment against them when they move out 60 days from now? If that's the case, that is not something that they would have to make payments on a weekly or monthly basis. It would be a judgment that's attached to them that they would need to pay off over time. Eventually, if they didn't, their landlord could, send that to a collection agency or try and garnish wages. But that is like well beyond like anything that would happen in the imminent future. A lot of folks, if they're doing a move out date, any money that they have, they're going to need for a security deposit for their new place. So what I normally advise them is, you're going to owe your landlord a judgment of $1,500 or whatever it may be. Get yourself set up, find your new place, put down your security deposit. And once you can start paying that off, pay it off in the same manner that you used to pay rent. Once you're finished paying it off, contact me and we can do something to either have that mark satisfied or vacated. But those are the two main things. Almost always, it's either a pay and stay or a move out date.
Tom's point about setting expectations and kind of helping the client see the kind of scope of what's possible is really important. When I do my first intro to a client, I often will insert in that like, I'm doing this landlord tenant thing. I am not representing you on anything else. You don't want me to do your employment discrimination case. I am not the guy who can handle your tort. I am the guy who will fight his darndest to get you the best result in landlord tenant court. And let's talk about like what you want and what that means. And really having in mind that like paying something and staying or leaving after a certain point of time, and explaining kind of like there's a give and take to like on all of these things. So for example, if you can get out in 30 days realistically, that gives you a lot of leverage to then like reduce the amount that you're paying, maybe to zero, maybe to just the security deposit. If you need more time, you might have to give them some money as a show of good faith or something like that. And it's, that kind of balance between them is helpful. And it helps really people kind of think, because there are no free options in this business, and you've got to keep people realistic and keep their asks constrained, because a period of time is like, oh, can I have 6 months? This is no, they're probably never going to agree to that at all. The most realistically is 90 days, but in reality, I see more 60 days than anything else. I think that's the kind of median amount of time.
Yeah, I agree with that. Most landlord attorneys, the first thing they say off the bat is 30.
Yeah.
If I sometimes, and each scenario is different. So, be ready to, those are the two main things, a pay and stay or move out date, but be ready to pivot. If you have a client that they're really unhappy with the place and they've actually already kind of started moving out, let's say they owe like a ton of, a good amount of money, like 8,000, 9,000. If they can be out in a week or two, I would approach the landlord's lawyer and say, will you waive the entire balance if they return the keys in a week? Because that incentivizes them to do that. And then the way this will work is if you reach an agreement with the landlord, either you or the landlord's lawyer will, on one of the court has computers. If you have an FJD account, you can type up the agreement electronically. If you don't, you can handwrite it. And they're very basic. It'll be normally 3 bullet points. Number 1, tenant agrees to pay ongoing monthly rent by the 5th of each month beginning in October. Number 2, tenant agrees to pay $400 towards the back owed money by the 20th of each month beginning in October, and continuing until the arrears are paid in full. The thing with these agreements, like the pay and stay agreements, is they are binding, final, and non-appealable. So if a tenant is a day late or $1 short, they are in breach. And once they are in breach, the landlord can file a breach against them and take them back to court. And then it's very easy for them to get the tenant evicted at that point. The tenant can file an answer, and then, maybe they can work something out again with the landlord, but they're really not in good footing once it gets to that point. So they have to understand that number 1, any pay and stay that they're entering into, it needs to be realistic. That's one of the biggest things I see with tenants who are unrepresented, because I've represented some tenants on the post-settlement stage where a landlord had filed a breach against them. And one I did, it was actually, I remember it because it was pretty crazy. The judgment by agreement, JBA, which is what we call the settlements, it was something like that the tenant was to pay off $6,000 of the arrears within a week of the court date. And the tenant owed like 8,000 total. And then after that, they were going to pay like 500 a month. And so we went in front of the judge for the breach hearing. And I was like, Judge, it doesn't make any sense, like why even the landlord's lawyer, offered this. Like everyone can look at this objectively and understand that this is going to result in a breach. Like if this tenant had any lawyer in the county, no one would have let him sign this. So I think one of the things that helps tenants out the most, because most of these cases are going to end in settlements and JBAs, but the terms of the JBA will be much more feasible and realistic. And because sometimes tenants are so scared of court in the process that they, in the moment, will say, yeah, I can pay it off by next week. And it's like, all right, well, I respect that. And you want to get it over with. And I respect that. But I don't want you to kill yourself, because sometimes life happens. And if you need to put a couple extra dollars aside for X, Y, or Z, like would 200 on the 20th be more realistic? So that's like kind of what your role is, because sometimes you'll see if a tenant is representing themselves, it can be scary for a tenant who is coming in, they took off from work, maybe they have 3 kids with them in court, which is not uncommon, and they're kind of rushing and they sign up for something that they can't do, and then they're in breach of that. So kind of on the pay and stay end, making sure the numbers match so that they're not in breach, because again, they can't be late or short, but also on the move out side of things, seeing if you can get them a little bit more time, because sometimes you'll have a tenant that maybe would have agreed to 30 days, and then you get involved and you can get them to a 45-day or 60-day move out day, simply because you enter your appearance and then you tell their lawyer like, hey, we could resolve it today. It's the first listing. I'm not asking for a continuance, but like you're telling me you only go for 30 days. If I ask for continuance, that would extend the case 30 days. And then at that point, why don't we just dispose of it today and you give us 45 or 60? So those are really the areas where your advocacy will be helpful. When you show up to court, if you've never been in municipal court, landlord tenant court, it's on the 6th floor of 1339 Chestnut Street. Sometimes when you get in there, it's a little hectic. Most of the cases are normally in courtroom 3. You'll sign in. There will be an employee with the court who, will kind of tell you when the cases will be statused. The cases will all be statused by a trial commissioner before the judge comes out. The trial commissioner can honor some agreements between 2 parties, like, an agreed upon continuance or something like that. Anything that's going to be contested, the judge needs to come out for. If you're just going to work something out or talk to, the landlord's lawyer, you'll just tell the commissioner, good morning, my name is so-and-so. If you could just place this on hold, I'm going to go speak to opposing counsel. So you'll have ample time to work things out with the other lawyer.
So pausing on actual hearing date, you know, if you are a volunteer attorney, you will at some point have to enter in your appearance for the client. There are two ways that I do it. One is you can enter the appearance online using the municipal court's website. That's the website Tom was talking about earlier. You said it was FJD or yeah. So I just look like courts.phila.gov and then I like click through because like I'm a Neanderthal. But you go to the website and you should make an account if you're doing these sorts of cases because it's helpful. You can access the docket directly. You can access the files directly. And that's helpful for me because it's all in one place. And you can see kind of the history too. You can enter your appearance directly there. I generally have a rule where I don't enter my appearance until I'm in court with the person. And so that kind of process, you can enter your appearance in paper when you arrive. They keep forms in the courtroom and you just fill it out. You have to put the case number down. You have to put your bar number down and then you hand it to one of the staff. They're usually on like the right side of the room. And they enter your appearance for you. But if it's a continuance or you entered it before or you're trying to file something ahead of time, like you will have entered your appearance already. The other thing is, when you're starting a representation, I mentioned conflicts. I also want to mention, engagement letters. VIP has a form of engagement letter if you don't have one, but most law firms have a form that they want you to use for pro bono representations. And so you want to make sure in your first meeting with the client, you got that engagement letter together, you got a copy sent to them. I spend a little bit of time talking through the engagement letter and what it means and what their rights are, and then asking them to sign. My firm accepts electronic signature, even, an email back saying I accept is good and I can file that. And that's enough for me. But you want to make sure you understand your firm's procedures on that stuff and that you're doing what you're supposed to do. The engagement letter is really important in establishing your attorney-client relationship with the client, sets out the standards and kind of makes sure that things are clear. Because remember, on these attorney-client determinations, it's not what you think, it's what the client thinks in terms of what the actual relationship is. I wish I had more to say on this because maybe this could have been an ethics hour and not just general CLE, but just kind of pay attention to that sort of stuff. So you get to court, you enter your appearance. I'm just going to skip ahead. So like this stuff on the screen right now is like the case file, and it gives you kind of basic information about the property. So you'll see things like the term of the lease, that they're in compliance with the rental license requirements, that they had it for every month, that they gave a certificate of rental suitability, tells you when the property was built, and things like that. So it's just helpful to read through because it helps you understand the background and kind of the defenses you might have. The other thing is like the lead certification, or lead safe or lead free. And you'll see like, when the notice to vacate was given, if proper. And then, the other thing, probably to me, the most important thing is like this chart setting out the amount of rent they think is due and for when. And again, I look at this and I compare it to what's in the contract. And like sometimes people are charging late fees that aren't provided for in the agreement, or they're charging for parking, but the parking wasn't actually delinquent, things like that. So, reading through this and making sense of it, or like they add a water charge, but the lease is clear that water is covered under the rent. They're charging both rent and water. So it's like, making sense of that and like looking at this. So we talked a little on this one. We'll get to this one in a second. Hopefully it's not a screamola. So here we are. This is the entrance to the municipal court. You go in. I usually come in on the Chestnut Street side, but you can also come in on the back side. I think that's where Ubers like to go. I don't know. I usually Uber from to the office back from here. That's usually where they get you. But you go in, the elevators are on the left. You take the elevator. Is it the 7th floor, 6th floor? See, it's like, you go in the one elevator and it really has 2 buttons. It's like 6 and 13, I think, right? Or wherever many of you are experienced volunteers. You know what I mean? So it's hard to miss. You get up there, you go, and you have to go through security. Usually if you show your card, they don't put you through the mag detectors. But you have to usually put your bag through an x-ray. So if you were thinking to bring your emotional support hamster, maybe that's not the best idea. I'm trying to keep it light. I'm getting punchy. It's near the end and we've been talking a lot. But I'd say, so then you get to courtroom 3. If you go through, it's like you go through security and you go down the hall and it's basically to the right. And then, it's kind of in the corner. There's big open space. I usually tell the client, I usually try to get there, 10, 15 minutes before when the hearing start time is, but you can realistically get there at the time and be okay because they don't really start on time ever. I don't recommend that. I also tell the client as well, and I make sure I have a way to get in touch with the client because I'll meet them in person there. You can sit with them or not if you like in the benches. There's a spot set off against the far wall for counsel, and a lot of people end up sitting there. But what you want to do, and if you're prepping still or you've got other stuff going on, you can sit with the client or not. I usually do like to sit with the client, but that's just me. When you check in, you can look at the list and see what cases are on deck, and you have a sense of when your client's case is going to come up. So they're organized by order of like oldest case to newest case. And the landlord tenant numbers are such that they have the date of filing embedded in them and then kind of like a number for the day. So if you know what your client's case number is, you can find it in the list. It's like, 18 or 31 or whatever. The way the list gets called when the commissioner comes out is that individual plaintiffs will go one at a time, and they'll go through all of their cases, and it could jump around the list. So if the lawyer who is representing the landlord, when you're going to have to say anything. And, hopefully you've talked to them before that moment so they know you're there, but sometimes they don't, and sometimes you can't. But when you're in court that day, one of the usual suspects will walk up and they'll have like literally 20 cases. Some will be represented, some will not. They'll do all of theirs, and then those cases will follow them out of the room, and then you're kind of waiting your turn before you get to work and have your conversation. Anything to add on? Like the practical reality of being in the courtroom?
No,
Here, you're muted.
Thank you. It's things can seem a little chaotic and fast in there, like it's a high volume courtroom. But that also means you'll have time. Because your case is one of many. A lot of things work themselves out in court. Many of the times they work themselves out, and if you can work it out with the landlord's lawyer ahead of time, beautiful. If not, you'll have time in court to work it out. You'll even have time to go back and forth a little bit and convey different offers to your client. If you agree to a settlement with the landlord's attorney, one of you will draft that either on a computer, or you can ask one of the court employees for there's a handwritten form you can fill out. That will be something that will be submitted to court employees, and then a court employee will go over it with you, your client, the landlord, and the landlord's lawyer separately. And then everyone signs it. If you work out a settlement, it's nice because you don't have to go in front of the judge. You will only see the actual judge if your case is going to be a contested trial. But if you work out a settlement, it'll just be done between you, the landlord's lawyer, your client, and then a court employee that will document it in the court system. If that happens, your client will get a printout copy of the agreement. So they'll be able to keep that and know, okay, by the 5th of each month, I got to pay rent. And by the 20th, I got to pay $300 towards the back owed money. If you're unsure of who anybody is, or you need to find a lawyer or something, generally most of the people who work for the court will be able to point you in the right direction. You'll kind of know who they are because they have on court clothes and a court ID lanyard. So if you're ever unsure of something, I would just ask them where to go or who's who. I think they can normally point you in the right direction.
In terms of, so maybe let's talk a little bit about negotiating with opposing counsel. So I usually, once I have a lay of the land and I know what the client wants and I know what my defenses are and I know what I'm trying to do, I try to reach out to plaintiff's counsel and discuss with them what's going on and what's in the case and what we want and what's possible. Some of the time we get things resolved before even going to court that day, and that's great. Very often there's back and forth. And that is, if your defenses are straightforward, sometimes I've seen them like I raised a lead claim and they couldn't get the information and they didn't know, and then they made a continuance happen so they could get their act together. But that's fine. We got more time. It got resolved in the end anyway. So it's a strategic choice, and it depends on how you judge what's going to be in the best interest of your client and getting the result you want. You don't have to reach out to them ahead of time, but I think it's generally good practice and can be helpful and save the client. A lot of the times the clients have to miss work or have to arrange childcare or something to be at court. And so anything you can do to kind of get them a good result and make their life easier, right, is just good client service. Assuming you can't work things out over the phone, your first opportunity to really talk to them is often when they've got a line of 30 people waiting to talk to them. And as a volunteer, for me, I get pro bono credit just standing there. So, I'm usually very busy, but I can, work by email or whatever while I wait. So I have no problem being patient. And I think giving the air of someone who's not in a rush and is very happy to slow down and take the time to make sure this gets resolved gives me a little bit of leverage in the room. And I am very happy to, make the arguments and kind of negotiate things and reach a result. And that kind of comes down to the style you are as a person. Now, in my family, we have a saying: if you are fighting, you are losing. And I really do believe that in these negotiations with landlord's counsel, I try not to get into any arguments. I try not to rise to anything I think they say is wrong. I mostly just lay out what I think the facts are. I lay out what we want and how do we get to a deal? And, the art of conveying an offer and of kind of, setting a bar, maybe not coming out with your best offer initially, and then having room to give so that there feels like there's a give and take or a meeting in the middle, is a tactic that I have a good amount of success with. That said, if my defenses are really strong and I'm aware and they're aware, then I use that for the maximum leverage. And I'm always signaling to them that I'm happy to have this one go in front of the judge. And I think this case is particularly this is a tough one for you, and let's just why don't we just work this one out, and look, where you can keep the security deposit. I'm going to be out in 45 days, and I really because they're human beings too. They're the plaintiff's lawyers are looking to get paid. They're looking for a result that has their client happy, and getting to a result that is realistic, that is easy for them to get their client to accept, or easy for them to advocate for their client to accept, is really helpful. When I'm negotiating with the landlord's counsel, I don't ever bring the client. I often will have the client sit in the waiting area and keep them away from that. For one, to me, keeping them from having to deal with the kind of ickiness of the negotiation. Also, you don't know what the client will do or not. You can counsel them I am here to do this for you. I am your service provider. I'll take all the heat. I'll do all the arguing. Can be helpful, but they may say something really offensive to the client. They may say something that really touches on a nerve that the client has. So I don't bring the client when I'm negotiating with the landlord counsel. Sometimes landlord counsel will bring their client in front of me too. And sometimes they, like, maybe they think it's some advantage of like a 2-on-1, but mostly I don't ever fight with them. I'm usually talking, even when the client's talking to me, I'm usually talking to the lawyer. And if they say something that's wrong, I don't challenge them. If that's what they want to say, I'm not going to like raise it, because I'll get them to say it if we go in front of the judge, and I'll be like, well, Your Honor, here he is saying himself he doesn't think he needs to comply with the eviction diversion program, but the words in the statute are reasonable good faith compliance. He has testified to you that he has not complied. And then that also kind of, because where the judge has discretion, like in the eviction diversion program defense, brazenness should count as an aggravating factor in terms of making a decision. And so I'm just trying to be strategic. I'm trying to be careful. If their lawyer wants to catch and counsel them against saying that, that's their job. I'm not going to do their job for them. But, I try to like just conduct the meetings in a straightforward way. But like when I'm talking to the client, we should think about how we're going to get to a deal, and what can you accept. I think this is the first offer we want to make. And I think this is where we're going to end up. Are you good with both of those? And just really trying to make sure. And then I'll talk to them. I'll see what they're willing to offer. I can't say yes to any of the offers on the spot. I say, look, I got to talk with my client about this. And then I go back, and even if it's according to the plan I set out with the client, and I say, look, as predicted, they said no, they came back with this. I think we can go with this. And then we'll come back and we'll try again. And, that act of the bid and the ask and the give and the take is an important part of resolving these. I think in the time that we have up, so we want to leave a little time for questions in case people have them. The other thing I wanted to talk about was how these things get resolved. So the most common resolution in these when you're involved will be a judgment by agreement. That is what is the strongest position for plaintiff's counsel, because they have a judgment with a date that they can enforce if we don't comply, and is where plaintiff's lawyers are going to try and push you every single time you reach a negotiated conclusion. A judgment by agreement is enforceable, non-appealable. Tom was saying all this before, and it shows up on people's records. Now, if you end up in a situation where they only will accept a judgment by agreement, a couple of things to think about. Think about what condition the property needs to be left in and what's happening with the security deposit. Remember, like if the security deposit can reduce the balance owed, then that's great, and you should use it for that, because you're unlikely to ever get it back. Client usually has to return the place in broom swept clean condition, or free from damage caused by the tenant. That's what I like to make sure it says, right? And if that's especially important if there's a bunch of habitability issues or the reason we're moving out, and then they're like, oh, well, the tenant returned this place and there are cockroaches, there's water leaks, the one electric outlet works. Like you can say, well, we have a record of all of this and we didn't cause any of this damage. So I try to make sure to carve out the actual problems and not have the client I've never seen it happen, but it's not outside of the scope of reality where then you're sued again for additional damages or more. So, you try and protect. So judgment by agreement, most common thing. Another thing you try to get is that they'll agree to vacate the judgment once it's been satisfied in full. It helps a little bit in terms of like showing satisfaction, showing that it's no longer applicable. And it's a good thing. And usually you'll be the one to responsible for preparing that. And it's like a 1-page form. You get them to sign it. You file it on the website for the landlord tenant number. So that's the most common way that these things get resolved. And that's the one you're probably going to see the most of. You don't necessarily have to get a judgment though. There are other solutions you can reach. One that I've seen some success with is a judgment by agreement in escrow. Basically, I give you the ability to file a judgment by agreement if I breach the agreement, but there's no judgment. We're a negotiated agreement. We have a contract and we continue the case, until the agreement is satisfied. So set up a payment plan, set continuances maybe for every 2 months, and then check in with landlord's counsel before the hearing to have them confirm everything is in compliance and that they're going to continue it by agreement to the next date. Not every landlord council will do this. So, it's worth trying. Clients like this because they don't get a judgment on their record and there's nothing to vacate. Landlords don't like it because it's a barrier to them getting quick enforcement on their judgment. So, you can have also kind of a private settlement agreement too without a JBA and escrow. Same kind of deal. Usually the way that landlord gets comfortable is that they're continuing rather than like completely withdrawing. In the agreement, try to get them to say that they're going to withdraw with prejudice so that they're not trying to reclaim amounts in the future if there's ever a breach again. But those are kind of the main ways it's getting resolved outside of court. I guess the client could hypothetically come and like just pay the full amount on the day, but if they could do that, then it's unlikely that they're going through this program anyway. Did you have any more on those, Tom?
No, I agree with all of that. Yeah.
So I want to give the second CLE code. So it is APR 937. APR, that's capitalized, space 937.
Okay. We have about 5 minutes left. And so now this is an opportunity if people have any questions or maybe any comments. If you have a favorite tip, we'd love to hear that too. No questions is fine too, I think. Oh, go ahead.
Catherine, where do we put this APR code?
Oh, so we'll put the QR code up again and you can scan it here. I'll put it up now so people can do. Oh, it's in the beginning, but you just scan the same QR code and then say sign out. Let me just pull it up. There's a link now in the Zoom chat as well. Here, that's the QR code. I already so like you can, I filled in, and what you have to do is you put the two codes in. So put the first code in, comma, and then the second code, and then that'll give you the credit for both the hours. But so you're saying you're negotiating a private settlement. Yeah, so that's a really good result. So congratulations. But that is kind of the ideal way that these get resolved. And this is kind of a situation where you have to feel out what the client is concerned about. If they raise it specifically as an issue, then it's something you really got to push for. If it's not something that they're really concerned about, and like they're not saying like, oh, I want to buy a house in the next year, and they're not saying things like that to you, it's kind of one of those things that you can use as like a negotiating lever and feel out what's going to get the right result for the client based on what they need, what they want, where they're going. It's something that you should always try for, but if it's not something the client's particularly worried about, it's not something I highlight to them as a thing I lost. And it's not just a cover my butt situation. If it's not something that the client feels that they need, and I'm judging that strategically it costs us to get, I'll either put that in front of them and explain it to them, or kind of give them where we got and explain it at that point. And, that's good representation. So I think, and good job to you for getting that. What a good point.
Yeah, that sounds like a great outcome.
Yeah, I guess what I was getting at, I think like because the case is helpful.
They'd have to file again, I think, is the point. And if it's the thing is, if they dismiss with prejudice, so it's a really good result because the dismissal with prejudice means that they can't re-raise those rental periods again. And so if they tried, now it's going to be dicey because if there's literally a written agreement to pay this stuff, they might sue on breach of contract. breach of contract's a different animal. But given how landlord tenant court works, they're very cute about not saying you can make the same lead claims as a counterclaim and you have to file it under small claims. But I doubt that if they came with a landlord tenant case with this contract involved, a breach of this contract, I doubt they do the same thing where they'd say, oh, well, you have to bring that contract in small claims court to have it enforced. Yeah. So it's sorry I didn't appreciate the nuance of your question the first go around, but that's a good result and strange of them because I think the enforcement on the plaintiff side will be really hard.
That will be the benefit for you is that if all things fail and worst case scenario happens and your client for some reason just like falls on really hard financial times and can't pay rent at all moving forward, they will, because of this agreement, have much more time before the inevitable eviction if God forbid it gets to that point, because the landlord would have to restart the whole process, as opposed to if you did a JBA and they breached, then the landlord could just bring them right back instantly in the breach. So you bought them a lot more time if worst case scenario that happens.
Yeah, it's at least a good argument. I'd keep that one in the back pocket. Hopefully it never comes to be, but and that's unusual too, because I'll say that most of the time the plaintiff's bar is consistent. They're very experienced. They're very world weary. They're very overburdened because they come in with and I'm not saying we aren't, but I'm saying they come in with 20 cases, you get it resolved for them in a way that doesn't cause them a bunch of strain and ruin their business. Usually they're more grateful than maybe they let on. But, so every now and again you get a result like that, and that's pretty cool. So it's you can feel it out too. But if it's I don't want to name any names because this is recorded, and I don't know if they ever listen to these or read the summaries.
I've heard that they do.
Oh, they do? All right. So then I have my eye on you. I think that's our camera. But I think if you can feel out that you've got an advantage in terms of experience or knowledge, subtly use it. We're zealous advocates for our clients. Don't ruin any, don't start the judge on a path to foreclosing on the lawyer's house, right? But yeah, do the best you can. If you can get that, great. All right.
One other tip regarding the rental license. This happened to me with my client actually picked us up, that they realized that the rental license number had a smudge around it on the copy. So we went online and checked the rental license number, and we realized that rental license number was for a different property. Apparently this landlord owned multiple properties. He couldn't get a rental license for the one he was suing us on. So he crossed it out and put in the number of he did have a license.
I have seen this kind of amateur document editing thing come up too. And so this is so hopefully everybody heard Willie's point, but please, it is critical. Check the license number yourself and check to make sure that the property has the rental license, because people editing a PDF is not hard. And people will do it in brazen ways that are very transparent. And even if the editing is pristine, that's why I always check myself, even if something is attached, because the court staff may not dig in deeper. They might just say, this is on my checklist. It appears, check-a-rooney, we're done. But thank you for that. We are at our time. So does anybody else have anything else before we close out? Oh yeah, of course. Yeah.
Okay, well, my contact information is in the chat. We're trying to get it now, but it's not working. So
I can do it over there, but go ahead.
okay. Well, thank you so much, Tom and John. That was a great presentation. I feel like we all learned a lot, and hopefully you guys are interested in taking a case. Right now, all of our cases are actually placed if you go on the website. However, I have received a slew of new cases. So if you are interested in one, please reach out to me. I have to, get in contact with the clients, work them up, but we will have plenty of options in the coming days. If you would like to take a case, there's my email. Please feel free to reach out about that or any other questions. And thank you very much.
Thanks,
Thank
everybody.
you. Thank you.